I'd like to thank everybody for joining us this afternoon for today's webinar. My name is Christopher Sanderson, and I am the IEEE R5 Houston Section Chair, as well as the IEEE R5 South Area Chair. Today's webinar came about really with the COVID-19 pandemic, which created a very unique challenge for all those that were impacted by the epidemic in the IEEE family. I would like to express my concern and support of all the members of the IEEE community, our members, our families, and all the others affected by this outbreak. I also would like to take this opportunity to say thank you to IEEE USA for partnering with us on this particular webinar. With that being said, I would like to introduce our guest speaker for today, Mr. Bert Jennings.
Chris, thank you for that introduction. Just when we were getting started, it started lightning over here, and unfortunately, my system shut down. So if everybody would bear with me for just a moment, I'll get the course opened up and we'll get started. Let's see.
Well, Bert, I know that you're in Texas because if you don't like the weather, just wait a little while. It'll change.
Yeah, we had bad weather here last night and the power went out. So I am operating off my laptop. I'm operating off the battery now. So hopefully we won't have any more problems.
You should be fine. Right. We really appreciate your help.
All right, here we go. So thank you all. Thank you, Chris, for the wonderful introduction. I missed part of it, but I am Bert Jennings. I'm hailing from Houston, Texas. I am an IP attorney, and I work for LyondellBasell. I hail from the great state of Mississippi, and Moss Point, Mississippi, to be exact, in Pascagoula, where we have the great Ingalls Shipbuilding. Ingalls Shipbuilding, we build ships for the Navy. And that's what brought me up and got me interested in engineering. After going to Morehouse College and getting a degree in computer science, I went on to Clark Atlanta and received a Master's of Science in computer engineering. So just a little bit about me. As we go forward, I'll share a little bit more when we get to the personal reflections. So I'm elated to give you some thoughts on ethics and the importance in what we do. My goal is to give you some food for thought as we go about our day-to-day jobs, whatever your profession is, because I understand we don't just have engineers on this call. Most, if not all, professions have some form of code of ethics to attempt to define what is acceptable conduct within their respective fields. Doctors, lawyers, project managers, and yes, even engineers have codes of ethics. Professional engineering PE's Code of Ethics can be found at the National Society for Professional Engineers, which is nspe.org. You go to their website, and that's also where a lot of the pre-reading materials, as far as the examples, came from. With an understanding of the code, it is hoped that the professional will be able to apply them to situations and circumstances, and with the use of good common sense, be able to arrive at some acceptable professional actions. So what we'll talk about today, I just gave an introduction. What we'll talk about today, I'm going to give a general discussion on law and ethics. We're going to go through the IEEE Code of Ethics, and I'm going to apologize up front. We're going to do a little reading of slides there. It's important that we get that down. We're going to have a discussion on some examples and where they appear, where the Code of Ethics have been applied. And then there's going to be some personal reflections and impacts, and then we will conclude. All right, so starting the introduction into ethics. Ethics, or moral philosophy, is a branch of philosophy that involves systematizing or defining and defending and recommending concepts of what's right and wrong conduct. Ethics seeks to resolve questions of human morality by defining concepts such as good and evil, right and wrong, vice and virtue, justice and crime. We get many of our moral and ethical theories, many of our actions under the Code of Ethics are based on some moral and ethical theories based on Western cultural traditions. This slide is meant to depict Socrates and Aristotle when it comes to Socratic and Aristotelian thought. Um, that's the basis for what engineers apply when it comes to the Code of Ethics. Uh, Aristotle's ethics, or the study of character, is built around the premise that people should achieve an excellent character, or what he called a virtuous character, as a precondition for attaining happiness and well being. Socrates thought that knowledge is virtue and virtue leads to happiness. It makes sense to think that moral people know what morality is. If you know right from wrong, then you might be able to choose to do what you know to be right. So Socrates identifies knowledge and virtue. If knowledge can be learned, so can virtue. Thus, Socrates states virtue can be taught. He believed that the unexamined life is not worth living. One must seek knowledge and wisdom before private interest. There it goes into ethics. Before private interest. In this manner, knowledge is sought as a means of ethical action, as a means of and to ethical action. Okay, so the law is described as a set of rules and regulations created by the government to govern a society. Law is universally accepted and recognized and enforced, and it's created with the purpose of maintaining social order, peace, and justice in our society, and to promote protection to the general public and safeguard our interests. Its aim is equal treatment of all. Law is generally made after considering ethical principles and ethical values, the social mores of our society. The law is made by the legislative branch, by Congress, and is interpreted by our judicial branches, our judicial branch, the judges and the courts. Every person in the country is bound to follow the law. It clearly defines what a person must or what a person must not do. So in the case of breach of law, it may result in confinement, confinement punishment, or financial penalty, or sometimes both. Courts look for predictable outcomes when settling disputes and determining punishment by basing their decisions on the law and previous outcomes, judicial precedent, and social practice as well. So the system is far from perfect, though. Sometimes ethics and morals and what is just plain right dictate a different outcome that may be different from the law or judicial precedents. Thus, one should follow the law with an anticipation of ethics, what is right and what is wrong in a particular circumstance. So you should always consider what is right and what is wrong, no matter what the law says. By ethics, we mean that branch of moral philosophy that guides people about what is good and what is bad. It is a collection of fundamental concepts and principles of an ideal human character. Ethics are the code of conduct agreed and adopted by the people. It's a set of standards on how a person should live and interact with other people in a society as a whole. The principles help us in making decisions regarding what is right and what is wrong. It informs us of how to act in a particular situation and make judgments to make better choices for ourselves. Ultimately, if all works well, ethics make their way into the laws promulgated and passed by Congress. Law and ethics are different, though. It delimits that line, that fine line between will and should, what a person must do versus what a person should do. The former is universally accepted, while the latter is ideal human conduct, agreed upon by most people. Confusing? You bet it's confusing. It's absolutely confusing. There is always an attempt to align both law and ethics so that they do not contradict each other. However, this alignment is not always perfect. What else would our legislators do? How else would they make their money? They strive to conform our laws to our ethics, to recap the difference between law, and ethics. Law is defined as a systematic body of rules that governs a society and actions of its individual members. Ethics means the science of a standard human conduct. Laws consist of a set of rules and regulations, whereas ethics comprises guidelines and principles that inform people on how to live or how to behave in a particular situation or in a particular profession. The law is created by the government, which may be local, regional, national, or international. On the other hand, ethics are governed by an individual, legal, or professional groups and norms, such as workplace ethics or such as environmental ethics, and so on. Breach of the law may result in punishment or penalty, or both, which is not in the case of a breach of ethics, which involves loss of trust and confidence, loss of reputation, or even embarrassment. Law is binding on its citizens and its people. Ethics have no such binding on the people. In the end, remember, what is legal may not be ethical, and what is ethical may not be legal. So now what we're going to do is, and again, my apologies because we're going to do a little slide reading here. But oftentimes in professional ethics seminars, that is the only time we get to examine or revisit the oath and code of ethics that we signed up for when we signed up for membership in the society. This code can be viewed as the Constitution, just like we have a Constitution of our United States. This is the Constitution of the professional society. So when joining IEEE, many of you are members of IEEE, you may have had to recite the following, or you may have had to sign an acknowledgement in your membership application stating the following. We, the members of IEEE, in recognition of the importance of our technology in affecting the quality of life throughout the world, and in accepting a personal obligation to our profession, its members, and communities we serve, do hereby commit ourselves to the highest ethical and professional conduct and agree as follows. And then it falls into what we see here on the screen, the preamble. Engineers affect the quality of life of all people in our complex technological society. In pursuit of their profession, therefore, it is vital that engineers conduct their work in an ethical manner so that they merit the confidence of colleagues, employers, clients, and the public. This IEEE Code of Ethics is a standard of professional conduct for engineers. So Article 1 of our Code of Ethics. Engineers shall maintain high standards of diligence, creativity, and productivity, and shall accept responsibility for their actions, be honest and realistic in stating claims or estimates from available data, undertake engineering tasks, and accept responsibility only if qualified by training or experience, or after full disclosure to their employers or clients of pertinent qualifications. Maintain their professional skills at a level of the state of the art and recognize the importance of current events in their work. And finally, advance the integrity and prestige of the engineering profession by practicing in a dignified manner and for adequate compensation. I always like the for adequate compensation. This Article 1 represents a duty to the profession, a duty to the job. Article 2. Article 2, engineers shall in their work treat all colleagues and co-workers fairly, regardless of race, religion, sex, age, or national origin. Report, publish, and disseminate freely information to others, subject to legal and proprietary restraints. Encourage colleagues and coworkers to act in accord with this code and support them when they do so. Seek, accept, and offer honest criticism of work and properly credit the contribution of others. Support and participate in activities of their professional societies. Finally, assist colleagues and coworkers in their professional development. I refer to this article as the duty to other professionals, the duty to other colleagues. It's important to note that to treat fairly all persons, regardless of such factors as race, religion, gender, disability, age, and national origin. In the law, these are what we call protected classes. Through judicial interpretation, also included in those classes are color. Color is different than race, but color, ethnicity, pregnancy, gender identity or expression, sexual orientation, marital status, citizen status, and veteran status. These are all things that have been judicially created based on an interpretation of the protected classes. Also important in this article is to seek and accept or offer honest criticism of technical work, including to acknowledge and correct errors. That's also included in number 4. And finally, in number 6, in assisting colleagues and coworkers in their professional development, this includes supporting them in following this code of ethics. And I think that's actually mentioned in Article 3 in Vignette 3 as well. Okay, going to Article 3. Article 3 is what I refer to as engineers' duties to employers and clients. Article 3, engineers shall, in their relation with employers and clients, act as faithful agents and trustees for their employers or clients in professional and business matters, provided such actions conform with other parts of this code. Again, if you want to take that apart, the duty to society and the duty to safety may actually trump this, but in most instances, in all instances, when you can do both, you should act faithfully and show a duty towards your employer or your client. Number 2, keep information on business affairs and technical processes of the employer or client in confidence while employed, and later until such information is properly released, provided such actions conform with other parts of this code. Again, just because you leave the employ of someone does not mean that that information that you attained while you were with that employer is freely available for you to use. You must maintain your duty of confidentiality to that employer, to that past employer. In most instances, you might be going to work for a competitor, and if you are, it's important that you recognize that. Inform the employer, client, professional societies, or public agencies or private agencies of which they are members or to which they may make presentations of any circumstance that can lead to a conflict of interest. Conflict of interest, that's most important, and we'll talk about that a little bit further in the presentation. Article 3 is a long one. Engineers shall continue in their relations with their employers and their clients to neither give nor accept directly or indirectly any gift, payment, or service or more than nominal value to or from those having business relationships with their employers or clients. And as we'll state later on in the presentation, when in doubt, disclose. Assist and advise their employers and clients in anticipating the possible consequences, direct and indirect, immediate or remote, of the projects, works, or plans for which they have knowledge. And finally, Article 5. There are only 5 articles. One thing I wanted to add, and let's go back a slide. One thing I wanted to add here is, when we think about that last vignette, I think about J. Robert Oppenheimer. He was the creator of the atomic bomb. When he had his first successful detonation on July 16th of 1945, he instantly realized his ethical dilemma. He remarked from the Bhagavad Gita, Bhagavad Gita. Oh man, I'm mispronouncing that. But what he said was, now I become the destroyer. Now I become death, the destroyer of worlds. Of course, when this bomb detonated, he instantly realized what could happen with that bomb. And that bomb was used on Hiroshima and Nagasaki, instantly killing thousands. It did end the war, but he felt that ethical dilemma when he actually created it. It's like Pandora's box, he couldn't put it back. All right, so let's go to 4. Again, this is the duty to the community, to the society, to the public. Engineers shall, in fulfillment of their responsibilities to the community, protect the safety, health, and welfare of the public and speak out against abuses in these areas affecting public interest. Contribute professional advice as appropriate to civic, charitable, and other nonprofit organizations, and seek to extend public knowledge and appreciation of the engineering profession and its achievements. Most notably in Article 4, we have to make sure that in our work, we adhere to safety, health, and welfare of the public. All right, so when making an ethical decision, basically you just have to answer some questions. You have to say, am I following the applicable laws and regulations? Is the action legal? Is it ethical? If that's yes, am I following the company's policies and values? Have I considered all the options? And then if that's yes, have I considered the implications of my decision? Would I feel comfortable if my decision were made public? If you answer no to any of these questions, then you should not act. And if you are faced with an ethical dilemma within your company, you should go to your manager or human resources or your legal department. Or in most instances, companies have what we call an ethics hotline. Go ahead and make the call on the ethics hotline. A lot of the times it's anonymous. All right, so we're going to fall into business practices. And when we talk about business practices, we are talking about different transactions that can happen as you represent your company and the ethical considerations that you must have there. Okay, in accordance with Article 3 of the Code, in avoiding conflicts of interest, you should always act in the best interest of your employer. You should always act in the best interest of your employer and not permit outside interest to interfere with your job duties. That includes family members. That includes financial and personal interests. Conflicts of interest can also call into question your judgment and the company's products and services. By knowing how to recognize and disclose and avoid potential conflicts, we protect our reputation and the reputation of our company and our ability to do business effectively. As a policy, again, no private gain or benefit for yourself or any family members. So, application, conflicts of interest and application. Avoid situations that could comprise or appear compromise, I'm sorry, that could compromise or appear to compromise your judgment. Put the company's interest in any business transaction ahead of your personal interest or gain, and disclose any potential conflicts in writing to your manager, human resources, or to the legal department to resolve the conflict. Keep in mind that not all conflicts are prohibited. Sometimes you can have a conflict as long as those conflicts are disclosed. They can be permissible if they are disclosed and approved. It's not always clear whether an activity creates a conflict of interest. However, it is the responsibility of every employee to disclose any potential conflict of interest. So, in other words, in application, when in doubt, disclose. Employees should recognize any potential conflicts or questions about how to handle a situation and where the conflict may exist, and disclose that to the legal department or to your manager or to the human resources department. And I'll say something here: if you disclose it to your manager and you don't get any kind of approval or anything, then you may need to look to disclose it to the legal department or to human resources, because you want to get approval, and in most instances, I say in all instances, you want to get that approval in writing. By way of examples of conflicts of interest, Avoid hiring, supervising, or promoting persons with whom you have a close relationship or influence their compensation, benefits, or opportunities if they work at the company. Avoid participating in transactions between the company and businesses that are owned by or that employ someone with whom you have a close relationship. And loans by the company to or guarantees by the company of obligations of any director, officer, any employees, their family members are expressly prohibited. And another note here is it may be a conflict of interest if you know someone with whom you have a close relationship that owns 1% of a customer, supplier, or competitor. So again, it's important when in doubt to disclose. Let's briefly talk about receiving gifts and entertainment. Accepting gifts and entertainment may be a conflict of interest and appear to limit your ability to make an objective business decision that would be in the best interest of the company. If you are offered a gift of entertainment or entertainment, ensure that it is not intended or might be seen to influence business decisions. So it doesn't have to necessarily be intended. If it would be seen to influence your business decision, then you should not accept it. It is not cash or the equivalent of cash. It does not exceed the company's monetary limit. If it does, politely decline and explain the company's policy. There is a legitimate business interest for accepting the gift or entertainment. It remains one-off or irregular in nature. In all cases, you should report it to your manager. Um, in exceptional situations where a gift must be accepted to avoid causing serious offense, in some cultures it would be offensive to return a gift or not accept a gift. Um, or a circumstance genuinely precludes you from returning it, you should consult your manager, human resources, legal department for guidance on how to properly handle and or dispose of the gift. A bit on fair dealing in business transactions. Deal fairly with the company's customers, suppliers, partners, service providers, competitors, employees, and anyone else with whom you have contact in the course of performing a job. Do not take unfair advantage of anyone through manipulation, concealment, abuse of privileged information, misrepresentation of facts, or any other unfair dealing practice. You got to be honest and accurate in advertising and marketing claims and avoid exaggerations, misrepresentations, and ambiguity. Take special care when making comparative claims not to disparage or unfairly criticize a competitor's products or services. That can be commonplace in many of our businesses, but take special care not to do that, for you may find yourself on the other end of a tortuous interference of business contract claim or something like that. Do not gather competitive intelligence in unlawful or unethical ways. It's okay to gather competitive intelligence, but you should not use unlawful or unethical ways. Under anti-competitive conduct, competition and antitrust laws prohibit making agreements with competitors, customers, suppliers, or other third parties that limit competition. Abide by all competition and antitrust laws that apply, avoiding situations that put you at risk of even appearing to violate these laws. You can't enter into arrangements where you're going to set a price in a particular market with a competitor. That's that's anti-competitive, and that is actionable under the law. You can hurt the company's reputation, and you risk substantial fines and even criminal prosecution if you do this. So, in application, what should you look at in application of anti-competitive conduct? Do not engage in discussions with competitors to fix prices. That's what I was just talking about. Divide sales opportunities or territories. Agree not to solicit each other's customers. Boycott or refuse to sell a particular product to a certain customer, supplier, or vendor. Rig bids. You should not rig bids. It should not be a sham bid. Share confidential information about pricing, profits, costs, sales terms, credit terms, customers, discounts, promotions, or any other information that might be sensitive information. You should not share that information. Competition and antitrust laws are complex and vary from country to country. Consult the legal department before taking any action that might be considered anti-competitive. You should seek the legal department's advice before you sell below costs or use pricing such as deep discounts or licensing terms to keep out unduly hinder competitors. Tie the sale or discount of any product or service to another product or service. Microsoft had an issue with that when they were trying to tie the operating system in with the actual machine. Enter an exclusive dealing or lock-in agreement. Treat customers, suppliers, or distributors inequitably for the same products. Restrict a distributor or agree to a restriction on who to sell to and at what price you're going to sell it to them. Impose or accept any non-compete or other similar restriction. In our company, anything that's non-compete has to go to the legal department for further review. Under anti-bribery and anti-corruption, do not tolerate bribery or corruption in any form in the private or public sector. Paying bribes or engaging in other corrupt activity can result in the company being prohibited from bidding on contracts, especially when it comes to government contracts, and personal and company fines or even imprisonment. You can go to prison for bribery. Bribery, corruption, and illegal payments all have deeply damaging impacts on society. They can harm economies, destabilize governments, and undermine public trust. In application, anti-bribery and anti-corruption do not accept, offer, or accept bribes or kickbacks. Do not make facilitating or grease payments, even if they are common in the country where requested. I've been practicing law a long time, and facilitating payments were not always objectionable or not always illegal. But because of international reach now, UK Bribery Act, which we'll briefly touch in a minute, makes facilitating payments expressly illegal. Report it if you're offered a bribe. Report it to your manager or the legal department if you're offered or asked to make a facilitating payment. Offer or accept only reasonable hospitality or business expenses, and record all payments and receipts honestly and accurately. You want to make sure that you keep a record of anything that is paid. Carry out risk-based due diligence before engaging any business partner. You want to know that you're doing business with a good partner before you sign the contract and before you engage them to be your agent. Communicate your company's anti-bribery policy to your business partner and watch out for red flags or signs that corrupt acts are likely to occur. If you learn that a business partner may have violated the standards of your company, consult with your legal department for how to mitigate or terminate the business relationship. The company expects all business partners to meet the standards, understanding that the company can be held liable for their actions, which reflect directly on the company. Take all reasonable steps to ensure business partners do not hire or do not engage in illegal or unethical conduct or actions and when acting on behalf of the company. So examples, bribes can take many forms, and it is important to actually review and know what could potentially be a bribe, because it might not in fact look like a bribe when it is offered to you. Anything of value being offered or given in exchange for favorable treatment. Cash, equivalents of cash, such as shares. Loans, Unreasonable gifts, entertainment, or hospitality, such as events, trips, or meals where there is no clear business purpose. Charitable donations. You may make a charitable donation in the name of, or someone may make a charitable donation in the name of your company. That is looked at as a bribe as well. Job offers, paid or unpaid interns, or favor for others. Uh, we really need to know, or you really need to be aware that bribes can take many different forms. Again, do not accept or give anything of value if it would appear to be improper or appear to improperly obligate someone to act a certain way, or if it would embarrass a party if it was made public. Before offering a gift, make sure the gift policy of your intended recipients will not be violated. Consult with the legal department before offering the gifts, meals, services, entertainment, or anything of value uh, to or from a government official. You know, it's important to realize this because it is part of doing business that certain things are offered, and they can be offered, but there is a fine line. And I would say in all instances, before you offer anything or before you accept anything, you should consult with your legal department. Under the U.S. Foreign Corrupt Practices Act, a government official includes, because remember, government official is a special category, it includes any director, officer, employee, agent, or representative, including anyone elected, nominated, appointed to be a director, officer, employee, or agent, or representative of any governmental entity, which includes state-owned businesses, such it could be a state-owned hospital, and international organizations, or anyone otherwise acting in the official capacity on behalf of a government entity. Any political party official, or political party employee, any candidate for public office uh, or political office, any royal or ruling family member, any agent or representative of any of the aforementioned. So um, make sure that you consider who you are about to exchange with, and make sure that they're not a government official. Again, when in doubt, talk to the legal department and have them do some investigation as to who you're actually talking with. Acceptable gifts and entertainment generally include promotional items with company logos, meals and entertainment of modest, not excessive value when business is conducted, tickets to a local sporting event or cultural event, gifts of nominal value that are customarily given on national holidays, prizes randomly given or received through raffles, contests, or industry events. And what I will tell you here is to check with your company's policies, because they may be more restrictive than this, and they may not allow you to accept any gifts whatsoever. So that is very important. This slide is meant to convey to you that anti-bribery and anti-corruption now has international reach. There is a saying under the U.S. Foreign Corrupt Practices Act, in that it follows the flag, meaning anybody who is a U.S. citizen, no matter what country they're doing business in, if they're a U.S. citizen, they are flying the U.S. flag, and they must adhere to the U.S. Foreign Corrupt Practices Act. The Organization of Economic Cooperative and Development, Cooperation and Development, the OECD, was established after World War II to promote policies and to promote and to improve economic and social well-being of people around the world, including many of the world's most advanced countries. So if you're doing business there, they probably have some sort of act underneath their law that subscribes or ascribes to the OECD standard. And then I also put here the UK Anti-Bribery Act, SAPIN 2 Anti-Corruption Act in France that was just passed in 2016, and the Clean Company Act, which is in Brazil. I think that was just passed in 2018. So some of these laws are very new, and they place upon you a high burden of what you can and can't do in those countries, regardless as to what the customs have been in the past. If you aren't sure of whether you should offer or accept a gift, ask yourself, what is the intention behind the gift? Would you feel uncomfortable or embarrassed if anyone else found out about it? Is the gift being offered outside of the workplace so that others will not know about it? Does the recipient have a policy that would prohibit it? Does it feel right? Or does something feel off? As you can see, these are ethical questions that you're asking yourself, but those ethical questions will lead to you following the law. Okay, hypothetical question. We engage a local agent with good connections to help us secure a government engineering, procurement, and construction contract. He wants to give a bottle of expensive liquor to a government official who signed off on the contract and insists that it is customary to do so. Could we get in trouble for that? Could you get in trouble for that? And the answer, yes, the company can be held responsible for the actions of the agent that is hired. You must tell the agent from the start not to give gifts to any public official. More importantly, before engaging this person, it is important to conduct due diligence on the agent and get a contractual assurance that no improper payments will be made on behalf of the company. Okay, real quickly, we're going to talk about company assets and information. So under company assets and information, we must protect the company assets and ensure their efficient use. Use the company assets only for legitimate business purposes, although incidental personal use may be permitted. You need to check with your company about that. Do not use company assets or information for personal gain. Do not take for yourself or your family members any opportunity that are discovered through use of company assets and information, and do not compete with the company based on the information that you receive. Don't compete with the company at all if you are employed with them. Company assets include physical assets such as computers, phones, mobile devices, machines, and vehicles. Intangible assets such as confidential or proprietary information, ideas, and inventions. Theft, carelessness, and waste have a direct impact on the company's profitability and are prohibited. All right, so when we use the term confidential information, what do we mean? It includes all non-public information, regardless of its source, that might be used to the company's competitors, by the company's competitors, or harmful to the company or its customers, suppliers, or partners if it is disclosed. Proprietary information includes intellectual property such as trade secrets, which are also confidential by their very nature, patents, trademarks, and copyrights, as well as business and marketing plans, engineering and manufacturing ideas. I'm going to include patent applications here because patent applications are actually confidential until they are published. Designs, databases, records of any non-public financial data or reports. Protect company information. We must protect the company's confidential information and proprietary information, maintain the confidentiality of information entrusted to you by the company or any of the company's customers, suppliers, or partners. So remember, you could be receiving confidential information from your customers, suppliers, or partners, and that has to be protected just as you would protect your own company's confidential information. Do not share the confidential information with anyone, including individuals within the company, unless they have a legitimate need to know and you are authorized to actually disclose it to them. As part of your job, you may learn or have access to non-public information regarding the company's business operations and customers. If this information is not public, it should be treated as confidential. Improper handling can cause damage to business relationships. It can hinder performance and be illegal and lead to civil and criminal penalties if it is disclosed. Trade secrets and other intellectual property, IP, including trademarks, service marks, copyrights, patents, patent applications, know-how, ideas, show how. There's a long litany of list of what things are examples of company information. Business strategy, operating plans, and outlooks. Company logos. The company name itself is a trademark, and the logo may be a trademark. Designs, product designs, new products, branding, marketing studies, All of this stuff, pricing information, all of this stuff is considered company information that is sensitive. Non-public information about company operations, processes, how they do business, IT systems. You don't want to engage in giving away the architecture of the IT system because that can lead or aid into hacking. Software, data, contracts, legal information. Uh, our employees and customers and business partners, a listing of our customers, our employees, or our business partners are also company information. Oops. Data that the company has a legal or contractual obligation to protect, such as credit card data, healthcare records under HIPAA, and personally identifiable information. In Europe, in the UK, there is a law that is specific to personally identifiable information, and we must follow that law. So put copyright notices on all company materials, information, and services and other products intended for public distribution. And you can easily find how to create a copyright notice. If you're going to be doing drawings, construction drawings, usually there's a stamp that's placed at the bottom of construction or engineering drawings, and that includes the copyright notice and how they can use that information. Respect the intellectual property of third parties, including competitors, and do not use um, in any way that violates the laws or the values or the company's values. Report any unauthorized usage of any of this information to the legal department. So data protection and privacy, just a little word on that. We have to understand how data is classified at the company. It can be highly confidential. It can just be confidential. Each company has its own schematic or Likert scale of the level of confidentiality that information needs to be kept. Collect, use, retain, and transfer data and information about individuals in accordance with the company policy and applicable data protection and privacy laws and regulations. If you're going to be transmitting this, it has to be encrypted. You may be able to only use storage devices that are company approved. But in all instances, obtain proper authorization before sharing the information. This area, data protection, is rapidly changing. So I would also suggest that you contact your company's legal department on their latest in data protection and privacy. All right, a hypothetical, real quick hypothetical. I recently joined the company from a competitor and have knowledge about some of the competitor's processes. Some of the information is confidential, but some, I believe, is not. If I am the manager, or if I'm asked by my manager, may I share this information? What is the answer? The answer is no. You still have a duty to that previous employer on that information. If the information is confidential, you have a personal legal obligation to your former employer to protect it from disclosure, just as you would if you left your company to work for another competitor. Sharing such information could put your company at legal risk. So I was once in a situation where we had an employee that left and went to another company and had engineering, design, and construction drawings on how to construct a plant that he had gotten from our company. And we had to go through a whole process to make sure that he understood that while, first off, that he had to give us those plans back. And second off, he really could not use those plans to further his work, even if he did create them himself while he was at our company. So remember, the information that you create while you're at the company generally belongs to the company. What you learn while you're doing that, and there's a fine line, what you learn while you're doing that, you can use general knowledge. Okay, so that was rather long, but what we're going to do now is I want to, in this last segment, I want to share some personal reflections and impacts of the Challenger accident. We've got about 9 minutes left. With the new SpaceX, and they attempted to launch and were not able to launch yesterday. this really hit home for me. I was in college when I watched the Challenger's ill-fated launch, and I thought this was important to share with you and the ethical concerns and considerations that some of the old engineers had to deal with. Okay, so on January 28th, 1986, 7 lives were lost as communications between engineers and scientists and executives failed in the face of public pressure to proceed with launch despite dangerously cold conditions. In the months that followed the accident, a presidential commission went through every piece of data and identified the root cause of the disaster. The commission ultimately flagged that the root cause of the disaster was serious flaw in the decision-making process leading up to launch. Several cases, studies also uh, uh, concluded that a cognitive bias referred to as groupthink was present. Groupthink was present in the decision-making process, which led to the Challenger explosion. So what is groupthink? A mode of thinking that people engage in when they are deeply involved in a cohesive in-group, when members strive for unanimity, overriding their motivation to realistically appraise alternative courses of action. This term was coined by the psychologist Dr. Irving Janis. The precursors to that are cohesive group, usually a group that's been working together for quite some time, insulation from experts. The decision makers want to be insulated from the experts, and usually there's a management structure there where the experts never get to talk to the decision makers. And leader preferences. There's usually someone that's in the group that leads the group and has all of the experience, and everybody just wants to go with what he says. While the symptoms support that groupthink was involved in a disaster, understanding the precursors can help us to avoid groupthink in future decisions. Illusions of invulnerability, these are some symptoms. Rationalization, inherent morality, stereotyped views of others, pressure on dissent, self-censorship. You might just not want to say what you're thinking. Illusions of unanimity and mind guarding. You want to guard what you know and not share it with others. So now what I'm going to do with the last few minutes I have is I'm going to share an article that was 30 years after the explosion. It was actually written January 28, 2016, and it was heard on a program, All Things Considered, NPR. So I'm going to click on this link, and hopefully you will be able to hear this brief 3-minute presentation. If there is a advertisement, I apologize up front.
Hi, folks. We're experiencing some technical difficulties with the audio for what Bert is playing, so please just wait a couple minutes as we fix it. Thanks.
Let me know.
Again, everybody, we apologize for not having the sound for this particular part of the presentation. What we will do is make sure that we will forward the link to the video so that you can listen to it in its entirely. Bert, if you don't mind, you just want to summarize what was shared in that NPR news. Bert, your mic is off.
Can you all hear me now?
Yes, sir, we can.
Okay, so sorry about that, and you just never can tell. Okay, let's get back to the presentation. What that was about was, and you can read it for yourself when you go to the link, and it actually plays for you, and it plays in Bob Ebling's own words that he tried to warn NASA management about the O-rings and about the weather and the fact that they would not expand, and unfortunately, he could not get them to listen, and some that did listen exercised groupthink and did not challenge the NASA management. And of course, you know what happened based on that. And then the second one, which again, I really wish you could have heard it in his own words. He basically said he thought he was a loser because he could not convince them that this was going to happen when he knew it was going to happen before it happened. And he had a big outpouring from not only NASA but his boss as well, and Morton Thiokol, just before he died, to say that that burden is not on you. You're one of the only people who came forward and you exercised your ethical duty, and it was us who did not. So it was a very touching article, and I do apologize that you all couldn't hear it. We'll share this with you. You can go out, you can listen to it. It's very touching. Okay, so let's wrap this up because we are right at 2:00. One last word. Let me go ahead and start this. Okay. Technical difficulties, I tell you. Okay. One last word. So what we have now is we have a pandemic that is going on, and how we are all affected, especially as engineers, by the decisions that we have to make as we open up this economy. We are being pressured, not only are Dr. Burke and Dr. Fauci being pressured uh, to not, well, uh, they are looking at science, but they are certainly being pressured not to go against the political wave that we have going on in this country. But we as engineers are asked to do a little bit of social engineering. We're asked to open up our businesses and arrange our offices so that we can practice safe distancing. We're being asked to, as some engineers and scientists are being asked to speed the development of detection devices to detect the virus. And some of those devices aren't working because they were developed too fast and not enough testing went into it. Vaccinations. I mean, you know, we talk about some of the drugs that are being tested and being used, and quite frankly, doctors are being asked to subscribe to, oh, this is good for challenging the virus or for getting people better. It's just all over the place with this COVID-19, and you best believe that ethics is at the heart of everything we're doing right now today. What we build, what we create, what we execute, it affects the lives. It affects our lives. It affects the public safety. It affects our loved ones. So, indeed, today this is very important as we have as we're over 100,000 deaths now. In any event, I'm going to end there. We're at 2 o'clock. I'm going to end there. I don't know if we have time for questions. If you have to go, I certainly can appreciate it. My information is there. If you have any questions, go ahead and reach out to me in LinkedIn. Just do a search on BertJennings.com. I think I'm the only Bert Jennings in LinkedIn currently. If you have any IP or patent legal services type questions, you can hit me up at Jennings Law Group. I try to fashion myself as an attorney that can give you a quick answer. If you work for a company that does not have an IP attorney that's working for it, I shall certainly try to do that. Special thanks to IEEE Houston section, Officer Christopher Sanderson, who without him, I would not be doing this. IEEE USA and LyondellBasell for providing me the opportunity to give this presentation. And special thanks to Daryl and Jonathan as well.
Awesome. So yes, folks, unfortunately, we're short on time and will not be able to get to questions today, but Bert has given his contact information, so feel free to reach out to Bert afterwards and he will get to them as soon as he's able to. Thank you so much, Bert and Chris, for joining us today. And thank you everyone for tuning in, and we hope you all have a great day.